The illegality of the international criminal courts and tribunals. The international courts and tribunals are a feature of an international system that is based on selectivity and double standards. What these courts have in common is their lack of the legal conditions for the existence of any court. The conditions of the legality of any court are well known. It must be established by a legitimate authority, whose legitimacy is derived from a legal status. The events brought before it must constitute clearly defined offenses established in a previous law that precedes their commission. The punishments of such acts must also be established in that law. The law must be enacted by a legitimate legislative authority. The judges of the court must enjoy full independence and the ability to make their rulings free from any outside influence. The rules of procedure of the court must ensure due process for the defendants. Do the international criminal courts and tribunals meet these conditions? The answer is no. In fact, the international criminal courts that the world have known were established in one of two ways. They were either established by the victors of a certain war, as was the case with the military tribunals of Nuremberg and Tokyo that were created by the victorious Allies after World War II, or by an international authority of dubious legitimacy, as was the case with the international tribunals for the former Yugoslavia and Rwanda that were created by the Security Council. In establishing the tribunals of Nuremberg and Tokyo in the wake of World War II, the Allies invoked only the legitimacy of the victors who were capable of imposing their terms on the vanquished. They created their tribunals in a manner that guarantees the condemnation of their enemies as criminals while absolving them of their own war crimes. Foremost among those crimes was the annihilation of hundreds of thousands of civilians by the use of a weapon that exceeds the needs of deterring the enemy, namely the atomic bomb. Those tribunals met none of the standards of justice in view of the following facts. They were created by the political leaders and military commanders of the occupation forces. Their judges were not impartial. They were themselves the opponents on the field of battle. In accordance with the recognized standards of justice, they were not qualified to play the role of a judge since they were party to the conflict. The defendants before those tribunals were prisoners of war. Under international law, they could not be brought to trial. The acts of which the defendants were tried were not crimes defined in and established by a previous law as justice requires. The list of crimes was established by the victorious Allies ex post facto after they were committed. This is in violation of the principle of legality of crimes and punishments. It also violates the principle of the non-retroactivity of the law. The Tokyo Tribunal was created by a special order of General MacArthur. That personal order established new, contrived crimes and offenses that existed only in MacArthur's imagination. Needless to say, the court under the law victimized many defenseless Japanese. The definition of the crimes of the defendants, if they can be described as crimes, was as continues to be the subject of disagreement among the countries of the world. The rulings of those tribunals were based on mere suspicion and doubts, not on proof and evidence. For instance, the Tokyo Tribunal condemned a Japanese commander for what is considered the crimes of the soldiers under his command in the Philippines. He was sentenced to death despite that the fact was not proven that he had given any orders. Indeed, he could not have known what had happened for the simple reason that he had fled the battlefield. Those tribunals were a sham whose only purpose was to provide justification for the conduct of the Allies who exceeded the legitimate right to self-defense. A proof of this is that unlike the other Allies, Russia, the country most devastated by the war, did not put any of the German military commanders in the part of Germany it occupied on trial. The international criminal courts are illegal. So are their sentences. Their victims and their relatives are entitled to just restitution and reparations for the injustice visited upon them. They are entitled to demand rehabilitation. The events of World War II must be brought once again before impartial courts that would reconsider the conduct of the victors and the vanquished alike. The earlier tribunals did not prosecute the crimes committed by both parties. They were confined to the prosecution of the vanquished alone. More importantly, the crimes for which they were tried had not been established in a previous law. Therefore, those tribunals violate the legal rule: nullum crimen nolla poena sine lege. No persecution for a crime unless pursuant to a previous law establishing that crime. The same applies to the international criminal tribunals for the former Yugoslavia and Rwanda. They were both established by the Security Council. The legitimacy of the council is dubious. It was created in the same manner and under the same circumstances in which the Nuremberg and Tokyo tribunals were established. It is yet another one of the products of World War II. The victors created the Security Council as a tool to shape international relations in the manner they saw fit. It was not created by the independent will and free choice of the states of the world. In addition, the security enforced the law. It has no right to enact it. Laws are enacted by the legislators elected by the people. The character of the council and the tasks it currently discharges are dubious because it represents only a minority. The states of the world did not take part in this creation. Therefore, it has no right to put their citizens on trial. Suffice it to recall that the International Court of Justice ruled that the Security Council had no jurisdiction over the Lockerbie question. Nevertheless, the Council disregarded that ruling and continued to address the Lockerbie question without any international legal basis. At the same time, the Council did not address the Court's ruling concerning the military and paramilitary activities in and against Nicaragua. The so-called Security Council has absolutely no legal right to establish courts or tribunals. Article 29 of the Charter cannot be construed as giving a right to establish courts. It only authorizes the establishment of subsidiary organs. The misuse of the Council of that and other provisions is a gross infringement upon the sovereignty of peoples. Therefore, the resolutions of the so-called Security Council pertaining to the establishment of courts and tribunals are null and void under international law and jurisprudence. The current international courts and tribunals were created in the fashion of their antecedents. Their purpose is not to try all those who may have committed a crime, but to try the weaker, vanquished party alone. In creating the two above-mentioned tribunals, the Council acted under Chapter 7 of the Charter. This is yet another proof of the politicized character and lack of impartiality. The Sierra Leone Tribunal is also illegal. Even if it was established on the basis of a request from the government of Sierra Leone, this does not give it the necessary legal conditions for a lawful court. It falls outside the national judicial system of Sierra Leone. Its statute and rulings are not subject to the supervision of that system for the following reasons. Number one, the statute of that tribunal is shaped in part on the basis of the so-called principles of international law derived from the statute and the rulings of another illegal court, that of Nuremberg. Number two, the president and prosecutor general of the tribunal are not from Sierra Leone. Number three, among its judges, there are foreign nationals who are not subject to the national sovereignty of which the judicial system is an integral part. Number four, the sentences passed by the tribunal will be implemented outside Sierra Leone. The International Criminal Court, ICC. The establishment of the ICC followed the same lines of the military and ad hoc international criminal tribunals. Although established by a treaty, its statute was based on the rules governing the above-mentioned international tribunals and on the rules of the Nuremberg trials. The inherent distortion has stripped it of its character as a court of law in the strict legal sense. This is evident in the following. Number one, the statute of the ICC allows the Security Council to request it to halt the proceedings of any case brought before it. Even if the Council abandons it, well-known selectivity and double standards in dealing with international peace and security, any relationship whatsoever it may have with the court negates the independence of the ICC and strips of its character as a court. This is born out of the fact that the Council exercised its tutelage over the court even before it started its work by adopting Resolution 1422, which constitutes a flagrant violation of the principle of the independence of the judiciary. Number two, thus far, the court does not have a unanimously agreed international legal text that establishes the offenses persecutable by it or the punishment for such offenses. The absence of this text renders the establishment of the court on the basis of the principle of the non-retroactivity of the law and the principle of legality, as contained in this statute, devoid of any practical value. Number three, the jurisdiction of the court does not cover the crime of aggression. That crime is the basis and the cause of all the other crimes covered by the jurisdiction of the ICC. Number four, the Rome Statute mentions the most grievous crimes while it ignores the lesser ones. This is a grave imbalance in the statute. That imbalance came into being upon the order of certain states. Number five, the court lacks the most basic guarantee of justice, namely, the right of defendants to legal defense, in that it is no different from the international criminal courts and tribunals where the matter of defense is a mere formality. Neither the tribunals nor the court have specific machinery for legal defense that assures defendants of a fair trial. Indeed, the draft code of professional conduct for lawyers and the standards and procedures for the provision of legal assistance was recently adopted to satisfy a formalistic requirement so that the court, if it can be called a court, could start its work. It was adopted without a study to ascertain its adequacy in assuring one of the most basic rights of the defendants.